Hello and welcome to second episode of Simply inTAXicating on GST Road Ahead. In the first episode, we had very engrossing debate on several constitutional issues, but the list is not yet over. Some of the key issues which are going to be discussed in this episode today are what is going to be the character of the GST Council? Is it going to be a judicial body or a legislative or executive body or a quasi-legislative cum judicial body? If its role is going to be a recommendatory as per the GST Bill, who would decide the GST rate? Given the fact that 1% additional tax is gone, why was 366(29)(a) retained? Is it a case of oversight or a deliberate decision? Let me now welcome my distinguished panelists today. We have Mr. Mohan Parasaran, former Solicitor General of India. We have Mr. Sujit Ghosh, partner, national head, Advaita Legal, and also our knowledge partner. We have Mr. S Dutt Majumder, former chairman, Central Board of Excise and Customs, and Mr. Sridhar, senior vice president, Hindustan, Coca. Welcome back, sirs. Let me go to Mr. Majumder first and find out how realistic is the time frame for the GST rollout, sir?
Now, coming back to your question that whether...
the luxury of time and the realistic deadline, yes, sir.
See, I'll go by what Finance Minister has said. Finance Minister has said that 1st April is the target. At the same time, in Hindi, he used the word, the akra rakna acha hai. I mean, there should be a target, the figure
Yes,
should be there.
Yes,
but
sir.
after that, as the things evolve, we'll see. So it's enough hint that if necessary, it may be delayed, if necessary.
Right,
and
sir.
I would like to clarify here that unlike your income tax, which is a financial year basis,
Right.
the GST is a transaction-based tax. So it can come on the first day of any month. So even if we miss 1st April, we can go to May, June, July, August. If you ask me my personal views, I would put the date as 1st October 2017. Not a month later than that, because after that, 2019, April, May, you are having your election. So October, and you know the history of GST. So October 2017 is my realistic target.
But sir, you know, one very important point is that a good number of corporates now, they have gone for computerization. They have ERP, they have software driven.
But
and these are not a small work. I have seen certain corporates taking almost 12 months.
No, they've started already. Customization of IT infrastructure.
We have started.
But the point here is that since you have raised this, again, may not be with the Constitution, but I'll just take 1 minute, please, or less than a minute. I think quite a few things have come in the public domain. Which has not come in the public domain is the GST net. What is happening in the GST net? What will be the structure of the GST net? All the stakeholders will have to interact with that common portal. But what is the features of that common portal so that I have to customize my IT infrastructure to interact with it? So that has not come forward. So we need that this should be there so that the traded industry, because this question has been raised by traded industry in different fora.
Right, sir.
So that is the thing.
So the finance minister statement on that was he's satisfied with the progress that has happened and he's expecting some pilot to come through by January or something.
He said that.
So that is one. But insofar as industry is concerned, and I actually sympathize with the industry because you see, software upgradation means a bunch of things. The fundamental thing in software upgradation is the definition. You have to define the software to behave in a certain pattern.
Right.
You can't do a definition of the software unless you know what the law is.
Correct.
Which kind of transactions to catch at what point in time. Rate is a very secondary issue. It's not. It's the smallest of the issue.
Correct.
Whether a job worker transaction shall be taxed in this manner and therefore the transaction pattern will be patched in this manner. So that whole definition of the software, which is what it is, programming is all about the definition.
Absolutely.
And Indian industry is resilient. Indian industry will go live on 1st April if it were to come.
Correct.
No rule, and they will learn faster than what the government will.
That's why I put
so therefore,
if 31st March the rules are coming, I put it at 1st
October.
They're very pragmatic and reasonable.
So that is one realistic thing, sir. So we will move to the GST Council now. I mean, that is another logical step from the Constitution Amendment. So what kind of challenges do you visualize, sir? Apart from the political challenges, of course, other challenges for the GST Council. And what could be the kind of model, ideal kind of configuration for the, the GST Council to begin with, to roll out, to herald the rollout of the GST. Ultimately, it's a GST Council which is going to notify a particular date.
See, I think the composition of this sort of a council itself is somewhat, I think, it is not, I would say it is not a judicial body.
Right, sir, okay.
It is essentially actually performing a legislative function.
Legislative come administrative sort of, sir, because
It is actually, yeah, legislative function and also an executive function in a sense, because Parliament has also delegated some of its powers to this council. I think this council should not be given the powers with regard to capping of rates, etc. Because again, actually, this will lead to a lot of disputes.
Oh, I see, sir.
And the Parliament itself actually should fix a definitive rate.
They can consult public bodies, or is there any question of, every proceeding has to be secret?
That's why I would actually relegate this council of having a power of a price fixation authority, and Supreme Court, it can be called as a quasi-legislative function.
So then they can't.
Once it is a quasi-legislative function, then Supreme Court has held in some cases that when they seek to actually affect rights of parties, including rights of business interests, like actually in the drug price fixation case, Justice Chinnapparadi held that you will have to give an opportunity of being heard. They will have to give an opportunity of being heard. But is it practicable? In what cases they will have to give an opportunity of being heard? Because their powers are so wide. No?
Yes.
One important thing is there in this, GST Council has only power to recommend. Because the supremacy of Parliament and supremacy of the legislature still remain.
Yes.
So, I presume that because they all are recommendations, that Parliament and legislature will have the authority to reject and go otherwise. So, what I am saying is that because Union Finance Minister will be the chairman of the GST Council, and after taking a sort of whatever is required to get the approval done, and one hand he recommends, and on the other hand in the Parliament he might...
because during our period, there are arguments on this.
Right.
Actually, the states wanted their recommendations to be binding on the Parliament also. Then we took the view that actually you can't actually make this Parliament subordinate to these authorities, because Parliament is supreme.
Right.
And therefore, we will normally be bound by you, but we can't put it in writing.
Right.
Just to clarify, our time, Professor means that's 2010-11.
10-11, right.
So, to answer your other question in terms of will they consult other bodies, etc., the amendment bill makes it very clear that the GST Council will draw up its own procedures of functioning.
Right.
And that procedure will be a subordinate legislation in which they will lay out how they will work out. So we can't at this point in time envisage what kind of consultation process they will go through. But surely whatever comes out in that particular bylaws that comes out is what will govern them.
Right. But still the question remains unanswered is, but how exactly the Parliament will decide the rate? I mean, that is...
No, but as Sir was saying, they will recommend it back to both the wings, the Parliament for the CGST and the states for the SGST, and that's it. But the larger question is also there. Now, if there is going to be a separate schedule, now the larger question is, since Sir is there, what happens? Do we as a country go with the HSN and go with the classification of HSN?
Right, yeah.
Or the bedrock of the central excise tariff legislation, which is very old in the country.
Right.
Now, will that be taken as the basis? or HSN will now be adopted and they'll go by those. How they will go? Because there has to be some modular principle by which they can put it into chapters and agree on the rates.
In fact, Sridhar, to your point, that's a very key point, because if you look at the products that have been excluded for the time being in the petroleum product, there is a blanket statement on natural gas. Now, gas in this country is in various forms: compressed natural gas, liquefied natural gas. The customs tariff of natural gas in liquefied form is 2711. In gaseous form, it is 2721. Now, if we go by simplicity and natural gas as is written, liquefied natural gas does not fall in, nor does CNG fall in. But that could not have been the intention, because natural gas is a common parlance as we understand it. LNG is a form of natural gas for purpose of transportation or whatever else. But then this kind of interpretive disputes will happen whether to get into the GST net or not get into the GST net. So that classification is, to my mind, the bedrock. And there is another problem. When you look at the rate fixation, etc., your charging section does not say that the tax will be levied on a value. In fact, they only say it shall be levied on the taxable person on the supply at a rate as may be specified in the schedule. The base of tax, which is the fundamental,
Right.
which is the fundamental, one of the four cornerstones of a perfect levy or a levy, valid levy, is missing. So value is missing, your classification of goods is missing, and nowhere in the schedules, nowhere in the body of the legislation, there is any mention of how the classification will happen. And some very complex issues comes out. And I'm taking the cue, I don't know whether that is there in our agenda, but I'll just bring it out. Goods have been defined in the Constitution in a manner to say it includes articles, commodities, etc. Services is residuary, anything other than that. Okay. So your power to levy GST is on supply of goods and supply of services, or both, which means the power to levy GST is restricted to goods as defined in the Constitution itself, services as defined in the Constitution itself. So the perimeter is drawn in the Constitution. When you look at the draft legislation, goods has a different meaning. It's a separate definition to the goods. Services has a different meaning. And interestingly, intangible properties are being considered and deemed to be services.
Right.
If you go by the Supreme Court TCS judgment, software has been held to be goods. So the definition of goods in the Constitution itself is capable of covering software. If the Constitution says that if goods means software and Constitution gives the power to levy GST only on goods of that kind that will include software, how can a subordinate legislation, which is the GST Act, carve out a distinction and change the whole track of what is goods? Because to my mind, the moment they do that, they will fall foul of the Constitution and will probably ultra vires. Second is your Schedule 2, etc., they have deemed various things as services. Okay. Now, to deem all of those things as services is disastrous, because then you are making something as goods and something as services as fungible, which is not permissible in the Constitution at all.
I think, Sujit, you should also ask, sir, at this stage,
Right.
the difference between the 115 and 122nd bill, one of the important differences is 36629A has been retained in this bill.
Right.
We must ask, sir, what is the need for keeping that? Is it meant for petroleum sectors and for other sectors? Why was this retained, sir? I mean, if there is some legal explanation why 36629A, which was removed in 115 bill, has been retained in the 122nd bill.
Possibly, I think, for the petroleum and
Petroleum.
I have some thoughts on that. If you look at 36029A, they talk about deemed sales in terms of leases, hire purchase, transfer of property during execution of work, supplies to hotels, etc., and two other categories, which is non-est. Actually, to my mind, it doesn't create too much of an issue. All of those have been deemed to be services. So 36029A, to my mind, is of no relevance today. Only reason why it could have been relevant, to my mind, and I'm thinking aloud here, is until this 1% additional tax was continuing, interstate supply of those would have been subject to works contract tax as well, or a lease tax as well, and therefore you needed 36029A to impose central sales tax.
So while scrapping that,
this should have automatically gone. So this should have automatically gone, but this 1% deletion happened now, so somebody may not have thought through. So when I was reasoning out why 36029A was kept in, the only thing it made sense was this 1%.
But also then if there is some work happening with regard to the petroleum sector,
it cannot.
Then how they
it
have
cannot
to be taxed somewhere because they are outside GST. So the 36629 may come to the rescue.
It cannot be. These are all consumables. It can never be leased. It can never be.
No, I don't know. Because
these are all
those
consumables.
People of those industry experts should be able to convey.
So I tell you, look at those goods. Motor spirit. It is inflammable. It is a consumable. It's not goods. It does not subsist. They cannot be transferred property in goods. Any number of Supreme Court decisions and High Court decisions on that. ATF, consumables. Aircraft, consumed. HSD, diesel, same thing. What is left? Crude. Always gets manufactured. It is never leased or it is never. So none of the ingredients of 3629A can ever be of any relevance.
Right. So petroleum particularly, yes.
Now you come to alcohol, which is outside. Alcohol is consumed.
Yes.
Have you ever seen a contract alcohol? Never.
Right.
So it, to my mind, is become odious. But they want to keep a vestigial provision. Let it be. There are so many things that are vestigial anyways.
It's course of time.
Somebody will wake up.
By abundant caution.
By abundant caution, something like that. Because your CST Act continues to operate, State Act continues to operate.
Or is it kept for
The
states?
CST will have
the
to
only
adapt to the
thing that
alcohol
we
is there.
could think of, which our internal team came up with an answer in the industry. Industry, we have a kind of a club that goes about education club.
Right.
One of the thought processes was, if one state, a server saying, Tamil Nadu, if they say that we are not going into GST, and if they want to be outside the GST, is it possible for them to?
No, absolutely.
No way.
Now
246
That is constitution. You will have a constitution.
They are a dissenting judge bound by the judgment.
Yeah.
Constitution.
Yes, that option is gone now. Yes, right. So we will go back to GST. Yes, so we have touched that. Yeah, adjudication, the dispute resolution is very important for the GST Council. That is, there, sir, you'd like to throw some light. How exactly?
Yes, he was the architect of that thing.
Resolution
the original
the entire
115
apparatus is going to
constitutional
work.
bill.
You know, and how constitutional that is going to be.
See, dispute resolution can't be handed over to this council. As I said, this is not a judicial body.
Right.
And this actually involves both the state and the union,
Right, sir.
or between two states. So, under the constitution, such disputes can only be resolved in an original suit under Article 131 before the Supreme Court. The President has got the powers to refer disputes between the states to an interstate council under Article 263, but that council also cannot adjudicate disputes. If an interstate council can't adjudicate disputes, how can this council adjudicate disputes?
Tribunal, water sharing.
Therefore, possibly, that was under the original constitution, which took away even the original jurisdiction of the Supreme Court. Article 262. Therefore, possibly, now you will have to take away this has to also amend Article 131, possibly take away the original jurisdiction even of the Supreme Court,
Right.
confer the jurisdiction on some tribunal
That was done with the
comprising of sitting or retired Supreme Court judges, and say that all original claims will only lie before that body, and possibly against that,
Appeal could be.
an appeal will only lie to Supreme Court.
So I have some thoughts on that. If you look at Article 131, it says subject to other provisions of the Constitution, which means 131 is subject to a rider. If you can find the rider within the Constitution, then 131 will not apply. 131 was interpreted by the Supreme Court, I think 7 judges bench, 6:1 majority, State of Karnataka versus Union of India, 6 SCC 608, if I remember right. Where they said that the purpose of this was to adjudicate a dispute, not a cause of action, a dispute, which is pertaining to an issue that that is relating to the legal rights of the states or the center. So the first question is that is there a legal right that we are talking about? Any power under the constitution is a legal right for the state, so that way it is fine. But then the judges went on to make this very clear statement on the objective of this article. If to ensure that one does not encroach into the other's domain or supremacy and they remain within their own areas. So state does not encroach into center and vice versa, state vis-a-vis the two states. That is the whole purpose, that you stay within your course, don't trespass. That is the objective of 131. That was then. If you look at the GST today, it's a common house today. There is no encroachment at all that we are talking about. Concurrent powers to central government, to the state governments to levy GST. Right. So how far 131 can even operate is my first question, and I don't have an answer. I'm only drawing a leaf from the 6:1 decision of the Supreme Court. That's one. Second, if you look at this GST Council, it is not going to resolve the dispute. It will only lay down the mechanism for resolving dispute. Now, the words mechanism is very important because mechanism by definition is procedure.
Correct.
Who confers the jurisdiction? GST Council cannot confer jurisdiction, it can only lay down the procedure. That if this is what to happen, you will file there, this is how we will format, etc., 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 all of those things.
It says shall establish a mechanism to adjudicate any dispute.
Correct. It
that
cannot,
is
exactly.
Yeah,
right. It's a mechanism. Mechanism cannot confer jurisdiction. So the jurisdiction will have to be conferred by the constitution in some manner, probably 131. So we come back to 131. So this whole conflict between supremacy of 131, which is subject to other provisions of the constitution, and the meaning of the word mechanism is therefore something that we'll have to deliberate. So it's going to be a vexed issue, and probably some view will have to be taken sooner or later.
So how exactly it will come out, or it will become transparent to the taxpayer? Is it the GST bill which is going to talk about it, or waste that authority in GST Council? GST Council in any case is going to talk about only put this apparatus in place. But so the power.
No, what I say is, even assuming, as I said, I agree, they might be exercising concurrent powers. But disputes always arise only when you exercise concurrent powers.
Right. Correct.
Between husband and wife.
Absolutely. Yes. Absolutely.
Therefore, how are you going to resolve that dispute?
That's a dispute. Yeah.
They are between state and the union or between two states.
Right.
Therefore, they have to naturally go before only the Supreme Court original jurisdiction. Now, actually, this council can't decide that. Nor council can't create a body because it is not a judicial forum.
Right.
Therefore, the parliament in the exercise of its constituent power can create a body, a judicial body, but it can't oust the jurisdiction of the Supreme Court.
Absolutely.
That's why in 115 Constitutional Amendment Bill, Person Sahab was our main advisor on that. That time it was thought that there will be independent dispute settlement authority, which will be headed by a retired Supreme Court judge or a retired Chief Justice of a High Court. It will have one eminent person from center, one eminent person from state, and appeals against those will go to Supreme Court. That was very clearly done, and the authority, jurisdiction, everything was there. That's why it was very clear cut. And at that time, if you recall, we had obtained Attorney General's opinion also.
Yes.
And he has very clearly said that it is not interfering with the fiscal autonomy of the states. Yes. Very clearly, I have quoted in my book about that.
Sir. So finally, it is going to be part of the GST legislation.
That was the but now it is not.
Sir, what is the option?
To my mind, it will not be part of the GST legislation at all, because it is a council's independent operation. What has the Constitutional Amendment Bill done? It has created a council, empowered the council to do a bunch of things.
Correct.
Which has nothing to do with the legislative power of the parliament or the state. That is independent. 246A, 279, all of those are independent. Using those powers in the Constitution Amendment Bill, the parliament will legislate the GST Act, IGST Act, etc., etc., and the state will do. What the council will come out with is a bylaw. It will come out with its own procedure. It will be an independent stream to my mind. As I see it, it will probably have nothing to do with, because it's not a dispute between taxpayer and the government.
Right.
You are trying to therefore say directly from 279A.
Correct. Absolutely. Right. It is not, because legislation is qua the assessee and the government.
Right.
Okay, that is where it is. There, the dispute resolution, appeal, etc., etc. But between states,
absolutely,
it has nothing to do with it. So it will be an independent thing that they will do, and it will be interesting to see how they come out. Because to my mind, a lot of litigation will happen on this point itself. Should I be bound by something such as this, which body probably has power or does not have power, and 131, etc., etc. And I was listening to Mr. Chidambaram a couple of days back. He seems to be worrying about this 131 as well. Yes. So there is Congress has taken a view that 131 needs to be looked at very closely. You cannot dilute 131. But then the points that I mentioned about 131, that it is subject to all of those things, those are things that will have to be debated now. So it's an issue.
Right, sir. So we have touched a lot of constitutional issues. The one point, perhaps the last point could be for this, because after Constitution and GST Council, perhaps the definition of goods.
Correct.
And the supply, perhaps.
Correct.
I mean, that is where we would like to throw some light
on
this.
So, 2-3 very, very fundamental issues have come up. I take the question of barter. Okay, now it doesn't bother too many people in the country, but should you have a barter, and which is a classical concept? They say supply includes XYZ, barter, exchange, etc., etc., etc. Now, when I do a barter, there's a two-way transaction that is happening. You give me that mug, that beautiful mug, and I give you this mobile phone. Are we saying there is a supply from me to you and therefore a tax, and a supply from you to me, therefore a tax? Okay, this is one issue. Now, there is a way to handle that also, that a barter is a barter if there is an underlying consideration. That underlying consideration is what you give me. Right. So, in my hand, what you are giving me is not goods, but it is the consideration for the goods that I have supplied to you. Right. In your hand, you have paid a consideration to get these goods. So, it will have to be only a one-way transaction. But this clarity needs to come out.
Who is to be taxed?
Who is to, exactly.
Absolutely.
Who is to tax? Okay.
That's very important.
Now, that's a very, very fine point that comes out because of the way it has been defined today. Correct. Second is, as I mentioned about this whole thing about software.
Right.
Forget about software for a moment. Let us look at the definition of services. It says anything other than goods is services. Constitution says anything other than goods. Tell me, will immole property not be services, therefore? Will immole property not be services? If services is defined to mean anything other than goods, immole property will be. Now, legislation, you may try to contain it by saying that, okay, following things shall be deemed to be a supply of goods and supply of services, and there you say renting of immole property is a service. But then you are creating a probable situation that you could also be taxing sale of immole property.
Yeah.
But I think, Shailendra, since you have gone into goods and services, I think we are very tempted from the industry to raise one more issue.
Right.
Schedule 1 is a perennial source of confusion on the self-supply. Free goods.
Self-supply, yeah.
Supply by one taxable person to another taxable person without consideration deemed to be supply.
Yeah. Let me wind up the debate and thank all my guests for contributing brilliant content, rather inputs for the lawmakers and the GST architects. Some of the important questions which need to be answered and certain points which need to be kept in mind before finalizing the key GST documents are: the Finance Minister needs to target October 2017 as a realistic deadline for GST implementation. Before that, if the GST draft rules are going to be public by 31st March, it's going to create problem for the SSEs. There is absolutely no need to repeat or to allow the history to repeat itself. What happened when we go back 10 years back to 2006-07, when the VAT was introduced? The country rolled into, many states rolled into VAT regime, but the rules were made available much later. Information about the preparedness of GST network should be made public as soon as possible, because ultimately everybody is going to work on the GST network. Definition of key legal terms such as supply should be quickly polished. No state will, of course, it has come out finally that no state will have freedom to opt out of GST. So that choice is gone. Another important point is, how is GST Council going to settle disputes? Whether a new judicial creature is going to be created to settle disputes between central and states or between two states? It is very clear that Mr. Arun Jaitley's plate is full of several complex issues which need to be sorted out before the GST is finally rolled out. Let me extend my special thanks to my knowledge partner, Mr. Sujit Ghosh, for making brilliant contribution to the entire gamut of issues. Thanking you all for watching TIOL Tube.